welcome to Legally Speaking with me, Tarun Nangia. Today, a landmark decision has been taken at a full court meeting presided over by Chief Justice of India, Justice LALIT. It was decided that constitutional cases will be live streamed henceforth. It is a landmark day in the history of the Indian court system that this decision has been taken, and it had to happen in the times of Justice LALIT, who in a short span is driving change in the judiciary. And that is what we would like to thank him for, and also discuss the far-reaching impact of the decision that he has taken. I have a very eminent panel who joins me today on this issue. May I welcome Ryan Karanjawala, Managing Partner, Karanjawala and Company, one of India's leading litigation law firms. Good to see you, Mr. Karanjawala. I would like to welcome Senior Advocate Parag Tripathi, top counsel at the Supreme Court of India, and many times provides us, in a sense, a certain relief when he uses certain couplets to convey his message. We're looking forward to more of these in today's show. I have with me Senior Advocate Amit Desai, top counsel at the Bombay High Court and the Supreme Court of India. He joins us from the city of Mumbai. Good to see you. I have with me Senior Advocate Percival Bilimoria, the counsel at the Delhi High Court and the Supreme Court, also does a lot of arbitration, international arbitration. Good to see you, Mr. Bilimoria. I would like to first start by congratulating Mohit Saraf. He just concluded a $10 billion deal between Vedanta and Foxconn, I think, which is now making headlines after the Vedanta promoter met our Prime Minister Narendra Modi. And I think the semiconductor plant will be in Narendra Modi's home state of Gujarat. So I think
Congratulations.
Thank you.
Congratulations.
Lots of good news, and may you continue to do such big deals of billions of dollars. I think this was a big one. So Mr. Mohit Saraf, Managing Partner of Saraf and Partners, joins us. And at the outset, may I request Mr. Karanjawala that in his opening comments, he could explain what happened in the court today, how this decision was taken, and also his opinion.
So essentially today, what has been decided is, it was something in the offing. It had started somewhere in Swapnil Tripathi's case, which was decided in the year 2018. But basically today, the full court sat together and took a decision under Justice Uday Lalit that from the 27th of September 22 this year, all constitutional bench matters will be subject to live streaming. Now, this is an extremely important decision and is a sort of a watershed in the annals of the court history, because though everyone knows that till now, every decision, every hearing of the court, except in those carved out exceptional cases, was always a public hearing. Now what is going to happen for the first time is that these decisions, this hearing will become permanently public, which means that it goes into the archives of the Supreme Court. 5 years later, at the click of a button, someone can access a particular counsel's argument in a particular matter at a particular point of time. And this is going to have its own sort of inbuilt processes which are going to reflect in the court itself. For example, I'll give you the reason why. Everyone, after all, Parliament has also had live streaming all these years. But insofar as parliamentary proceedings are concerned, people expected to have a little element of the rough and the tumble. You know, there's a little bit of back and forth, to and fro, and so on. But insofar as constitutional bench matters are concerned, people always believe that it is the embodiment of what people believe to be the majesty of the law. It's the complete embodiment of the majesty of the law. And that is why they will, in a sense, really have to put their best foot forward. Now, let me give you, and there will be, as they go along, I'm sure that they will find nuances and they will nuance the way they hear matters. Let me give you an example. Now, as you know, we've recently had a controversy where a judge said something in open court, it was reacted to on the internet, it was reacted to in the open public, there was a storm created, there was a back and forth on this particular issue. Now, in a constitutional bench matter, when 5 or 7 or 9 judges are sitting, different judges normally ask different questions at different points of time. But what happens is most constitutional bench matters have a certain political ramification or a certain fallout. For example, if you're hearing matters on the aspect of reservation. Now, it's a matter on which a lot of people have a lot of very strong views. So they might evolve a system where they start worrying if an individual judge asks a few questions, then will he get sort of attacked in public as having shown a particular slant or a particular bent of mind. And they might come out and do something like they did in the Ayodhya judgment. In the Ayodhya judgment, there was one judgment and it was of the court. So they may, in the years to come, sort of evolve a procedure where on a daily basis, one particular judge alone asks all the questions. So the other brothers just write out the question on a slip and give it to him, so that it becomes a question of the court and not the question of the individual judge. So that in a sense, a particular step, the court puts a particular step forward, which shows the court to be more neutral, or judges in a sense to be more neutral, just probing and asking rather than having individual judges later on singled out for asking this question to this person in this manner. So I'm sure this will be an evolving process. How it evolves further is something that we'll all have to watch and wait. Having said that, one must realize that already there are 6 high courts which are already having live streaming in there. But these are not, of course, constitution bench matters. You're on mute, Tarun.
Thanks for that opening comment and explaining to us what are the implications of this decision. I'll go to Senior Advocate Parag Tripathi. You spend a lot of your time arguing in court. And if you could, from that perspective, how this changes things for people who are interested in following. A lot of lawyers are interested in seeing what happens in these constitutional cases, not even the larger community, the legal community itself. What is your opinion on what Justice UU Lalit has driven? Because the full court took the decision, but of course we all concur it was driven by Justice UU Lalit.
Yes, I think it's a very interesting area of development. And I think, in a sense, we are now moving a little towards the American constitutional experience, where, of course, Chief Justices have a much longer term, and the courts are identified by the Chief Justice. What Justice Lalit has done is that despite a much shorter term, he is now fashioning what I call the Lalit Supreme Court. That's how they'll say it in the US, because he has done so many things which are unique and which have left a stamp, which is a welcome change, because we have had in the past some Chief Justices who have not left much of an impact. So this is an area where I think our court is also evolving, and 75 years is not too old an age to evolve, as we all know. But coming to the question as to how it is going to affect, it'll affect at 2 levels. One aspect which Ryan very correctly said is that it will lead to a more nuanced approach, both from the court and I'd say from the lawyers, because it's a new area, as it were, a new arena. Because you not only have to argue well as a lawyer, but you have to also look good while arguing as a lawyer. You're not to look mean. You're not to look unnecessarily tough. You have to look generous and yet make your point, because now you're on a public stage, and likewise on questions which come from the court. So this is one aspect. But there's one more aspect which troubles me in this, as one commentator, one actually jurisprudential scholar in a law review had said, this trial by Zoom. The problem here is that there is going to be instantaneous trolling. And that is an aspect which, of course, that is no reason to shut down this great experiment. But we have to educate our people that, look, you are a participant as a spectator, but you are like a spectator, you are like a National Geographic photographer when he takes photographs in the savannah. He does not interfere when there is a hunt going on. He only reports and understands. So you have to have that mindset as a spectator, that, look, it's a privilege, it's a part of my right, because I'm in a democracy, I'm a citizen, I elect the government. Therefore, I have a right, but I also have a responsibility not to go beyond. And since you have now typified me as somebody who must put in that couplet, I am putting that couplet, because you have to follow the tradition. And I'm just slightly changing what the great Mir had said. Mir had said, "Hum hue, tum hue, ki Mir hue, uski zulfon ke sab asir hue." Asir means kaidi. तो हम हुए कि तुम हुए कि मीर हुए, इस इंटरनेट के सभी असीर हुए. We are all, in a way, we are all chained by the internet, and we have to find ways to do it in a manner that it meets with our requirements of rule of law, of democracy, and most importantly, judicial independence. The judiciary should not be unduly taken in by the fact that they are being judged for something which is not law, something which is just first impression, which can sometime, if it is not structured properly, can lead to a lot of difficulties and problems.
Thanks for that opening comment and your signature couplet. And I'll take this to Senior Advocate Amit Desai, who has also been arguing a lot in front of his iPad and also in front of his, when I get to talk to him, sometimes he's appearing in the courts in Delhi online. But coming back to today's topic, Mr. Desai, what would you make of this decision driven by Justice UU Lalit?
So obviously, I don't think that there's any doubt or debate on the sort of the nature of this decision and what it's going to do to our judicial system. In any case, this decision was long overdue, because as the society is evolving, as technology is evolving, we've gone into this whole mode of video hearings, Zoom hearings, a lot of meetings are on Zoom. So a lot of people are getting used to the reality of communicating through this platform of technology, and arguing matters and having a large number of people watching them was a matter of time. So I think this is something which has been much wanted, much needed, and I think there are a lot of advantages to it. And then, as Parag said, also some disadvantages which need to be careful about. I think the advantages are very clear. I think you get to bring about. We are all lived in a concept of an open court. And what used to happen in the concept of an open court was that when we were in a physical space, we only used to have probably about 100 people who could manage to fit themselves into a courtroom and come and watch court proceedings. And this kind of live streaming really brings about the concept of an open court where the public can really step in and watch what's going on. So this is just an extension, a technological advancement of what is fundamental to our democratic values and court system of having open courtrooms. And we've just brought in the entire country and probably the world into the courtroom through this process. I think as Ryan and Parag mentioned, I think it will change the manner in which people argue. It will change the manner in which judges will ask questions. Everybody will, to some extent, be conscious. And I do hope that this does not become anywhere near like what we see in the parliament, which Ryan adverted to, because then in the parliament, we kind of see some really very interesting sights of mics being thrown from left to right and things like that. But I do believe that this will bring about a very dignified, over time, it'll bring about a very dignified manner in which constitutional issues are argued. Ryan rightly mentioned, he said that since this is an experiment starting with constitutional matters, these are the matters in which the public are really interested, because all constitutional issues are matters of extreme public interest. Otherwise, they wouldn't have landed up before a 5-judge court. So clearly, matters of moment, matters of public interest, matters of national importance are the matters which are going to be debated and discussed. The other good thing which I see about it is about the educative process that this is going to bring about. So when you look at what happens in law colleges and we talk about moot courts, you're now actually seeing live court performances, and these can be actually taken into the classrooms, so that when we are talking about very important issues of law, I mean, I just go back in time that if this live streaming was happening sometime in the 1970s and the full court listening to Keshav Nanda Bharti and Nani Palkhiwala's absolutely erudite exposition on the basic structure was being argued, and if I was to actually take this time back, I'm no doubt in my mind that every college in the country and every classroom would be actually sitting and watching that argument again and again, because there's a lot for the youngsters to learn. So what you have is, in any case, a lot of youngsters come into the courtrooms to watch advocacy skills. This is something that is going to actually help them in building up their advocacy skills whilst they're in their classrooms themselves. So I think there are many benefits to this. There's no doubt about it. I think the question which is really to be also assessed is an issue that you actually took up on the last occasion in your show, and that is about the implication about how social media tends to troll judges. And we had this whole debate, and I think you had many of the same panel on that show, where I think there was an expression of some concern that whilst judges use this platform to flesh out issues in the course of a hearing, the public and judge don't realize what the real intent of the judges are, and you have this entire process of trolling, and there's a need for a code. I think that is where we need to be careful, we need to be cautious, because as I had mentioned on that occasion also, that in a democracy, the institution of the judiciary, and this time it comes to the Constitutional Court, it comes to the Supreme Court, the integrity and the dignity of the institution is necessary to be maintained if we are to really have any kind of rule of law effectively in a country. Now, if there is a continuous trolling that happens and it denigrates the institution, then we have a problem. So we need to make sure that this part of the process of the social media to some extent is also brought under some form of control, because we do not want the reputation of the institution to be denigrated in any manner merely because we have so many people watching these proceedings. So I mean, whilst clearly, Ryan adverted to Swapnil Tripathi, I mean, of course, I must tell you that on a lighter note, Indira Jaising is very, very happy that this has happened, because she was part of that matter, and she's sort of been messaging everybody since morning saying that we've done it and thank you very much. But yeah, I mean, this is the moment, and I'm glad that it has been done now. Obviously, this is going to continue, and I think only expand, because with Justice Chandrachud, who also was part of that bench, is now obviously the next Chief Justice, and we all know that he's very keen to introduce a lot of technology. We see that, Justice Lalit has taken this decision, but this is going to be carried forward with Justice Chandrachud, and that's what is important also from an institutional perspective.
Thanks for that opening comment, Mr. Senior Advocate Amit Desai. I'll go to Mohit Saraf, Managing Partner of Saraf and Partners, for his opening comment on this decision taken by Justice UU Lalit and the judges of the Supreme Court of India.
Thank you, Tarun. I think all of us have been talking a lot about judicial reform, and this is the right time. And I was part of a committee which was headed by Justice Lopur and Justice Sikri, and which was organized by FICCI to write a report on judicial reform and largely improving enforceability of contract. And you know that on ease of doing business, we improved significantly. But on enforceability of contract, we are bottom 30 in the world. And that adds to the cost of infrastructure, it adds to cost of everything in India, and that's an important part. But we have to also remember that judiciary affects life of everybody, whether it's on constitutional issues or even contractual issues or a services issue. But if you think about this, really there is no mechanism to address grievances in the judicial system. And that's an important part. What this judgment does is, I would not just bring it that it only brings accountability to judges. Actually, it brings accountability to all stakeholders, be lawyers, be judges, be public prosecutors, how well they present the case, and the government. Because sometimes a lot of issues, government are not putting it in front, because judges can only take a decision what is being presented for it. Adjournment, lawyers taking adjournment. So I would say litigants, in India is a country where you can litigate for the heck of litigation, because the cost awarded is so small that it does not affect anybody to litigate. And I would say these are important issues. So therefore, what I see is this is really the first step to bringing an accountability, not to judges, but to the entire system, all of us. And all of us, our decision, our participation, public prosecutor, government, how they put things in front of the court, all these things will be looked at it. And I would say this will improve I would say this is a one step. It's like Ryan said, 6 courts have already implemented it. And it should not stop here. It should go full. I would say there will be, social media will always be there, and we have to live with it. But I would say eventually Justice Chandrachud has come up with guidelines involved with this entire live streaming. And I'm quite sure that they will keep fixing it. But we should not stop as the first step. Indra, she wanted it for even on all issues which relates to public policy. So I would say all those issues should get extended. And I would say a live streaming must be brought in. It will only improve. And I think these important issues or the side effects can always be, I would say, always be handled by appropriate guidelines.
Thanks for the opening comment, Mr. Saraf. I'll go to Senior Advocate Percival Bilimoria for his opening comment.
Thank you, Tarun. I think our Chief Justice has to be complimented for this initiative. It's a great move. From my experience in international arbitration, I can certainly tell you that there is an immense utility to live transcripts. I've seen it work. Unfortunately, we don't have it in India yet, which is a very odd situation. But as far as the Supreme Court is concerned, this is a great move. I'm not too worried about trolling because, as Mohit said, we have to live with this. In fact, the very fact that it is being recorded will prevent misinformation. So I see it as a very positive move. It will, prevent all kinds of rumors, etc., because you have the recording accessible. We know in what context. If you remember the previous session that we had, context matters. And that is where you could see the whole recording and then see for yourself and you'll stand corrected. So I'm not too worried about that at all.
But Tarun, what is important for you to notice is, like a lot of times says, this matter is such an important thing. It took 7 years for the court to decide. Now you will get to know what was the government role, what was the public prosecutor role, what was the lawyer's role. So I would say it's actually going to bring the entire accountability. And also great corporates will think 20 times before litigating for the heck of litigation, for delaying issues. So I would say it's an accountability to the entire, all the stakeholders will really matter.
Thanks, Mr. Saraf and Mr. Bilimoria for your comments. I'll go to Mr. Ryan Karanjawala and ask him, you answered this partially in your opening comment, but now as somebody whose law firms has so many matters on in the Supreme Court, many of constitutional importance, I would like to ask you this. Many times half arguments are done in court and a date is taken or the court awards a certain date. The lawyers may want to play devil's advocate and make certain contrarian arguments to derive at a certain position. And midway, if there is criticism of him in the outside world, even while he's building a certain argument just to, drive home his point, do you think these are things we have to live with when we are becoming an open society, as in open courts? Or do you think we will get to the answer to this issue slowly? Because I remember that when parliament proceedings were, opened, a lot of politicians said, and I think we have a discussion on this also, that parliamentarians are scared to speak in the Lok Sabha. They only play to the gallery. Work is done in parliamentary committees. Now, lawyers have no such option. They have to speak what it is. It is before the court. There is no other separate room where they can go and discuss with the judge that this is my argument. How will this progress?
See, lawyers will argue matters the way they normally argue matters, except with a little, perhaps, greater circumspection. And one good thing that will happen is that if you're on an open live streaming platform, the ability of a counsel to suddenly rush out of the court midway through arguments while the other side is arguing and rush back in, all gets a little diminished because, you're not only facing, you're not only having to deal with a sort of helpless but angry client, but the world at large is watching you. And so certainly what will happen is that there will be a greater amount of sort of readiness all round. Certainly as far as the bar is concerned, I think any live streaming option will put them on guard and at their best, which is always for the betterment of the whole legal process. So that is certainly one good outcoming which will come out of it. There will be other things will have to be seen as they go along.
See, I'll go to Senior Advocate Parag Tripathi. These days on YouTube and all, we see a lot of, from the Gujarat High Court, from the Patna High Court, the comments made by the judges, the comments made by the lawyers, they are going viral. But of course, these are other small matters, not major matters. But in Supreme Court, for example, an eminent counsel like you argues, and then there is hundreds of comments. I would have argued this. This point was not said. This point could have been made. These things do come. Do you think this should affect lawyers? Because these are eminent counsels of India. Or do you think you take it in your stride and go on?
I think there are two aspects to it. One is, of course, there is a public duty which lawyers perform. And certainly they have every obligation to listen to fair criticism. That's the only way you grow. The line has to be drawn between a fair criticism and trolling, or fair criticism and malicious criticism. But that, as Ryan says, and that's how Amit and Mohit and Prasad said, that over a period of time, things have a way of working themselves out. So it's not that it'll happen overnight. There will be teething problems. There will be issues which will arise. But I think over a period of time, it will work out. And there are two things which fascinate me here. One is a point already made by our panel here. That is that this is a great knowledge base. You will record it naturally.
Yeah.
Once you record it, it's a great knowledge base. It's an educational tool, not limited only to students, limited to all of us as well, because we can also say, how is it that this gentleman argued this and was able to persuade a court which was otherwise not with him? What did he do? So that's very important. And secondly, it raises a very interesting jurisprudential issue. Tarun, there's a huge debate as to what extent legislative assembly debates are relevant to interpret a law. Now, to what extent would let us say, Amit or Percival or Mohit argued in court, and what the judges reacted, how much is it relevant in interpreting the judgment? Because that's a completely new area which we have never looked at. So you say, look, this is the passage in the judgment, but this suffers from this error because the counsel didn't argue this and the judge misunderstood what he was saying. So it's a new arena, as it were, and fascinating, so long as everybody involved broadly functions in a bona fide way.
Point well taken. I'll go to Senior Advocate Amit Desai. Now, you have a problem in Mumbai, because at the Bombay High Court, when you go and argue, it's a constitutional course, everybody would want to know that what did Amit Desai say in court? So you would be scrutinized like nobody else in your city. Do you think that is something that is a predicament a lot of lawyers will have? That my every word is being taken out to smithereens by 10 people. What word he said, when did he say it, what kind of state, and the judge has the option to keep quiet, but you have no such option. The judge can, because he knows it's being live streamed, he can maybe stay silent, but you will have to speak nonetheless. How does this play out? You're not audible.
You're mute.
You kind of remind me of one of the biggest media trials which took place in the United States, O.J. Simpson. You remember that, right? So every aspect of that case on a day-to-day basis was being debated on television. Now, of course, I don't know what it did to Johnny Cochran, who was cross-examining the witnesses, and did it help him or did it ultimately affect him? But this is what is going to happen as a matter of reality. And as Parag said, listen, we as lawyers have to bear this on our shoulders and get on with it. But I think the important thing, and there are two sides to this we have to bear in mind. One is that as we argue in court, if we are conscious of the fact that the world is watching, then, as Ryan rightly said, every lawyer worth his salt would be more careful, more conscious, more diligent in ensuring that he has done his best, he's researched the law adequately, he's read his brief thoroughly, and he's put his best foot forward. And therefore, he would be open to very little criticism because he's actually covered all aspects of the matter. So it'll compel everybody to actually read their briefs in great detail and make sure that all the relevant arguments are put across. But the issue that I worry about at times is that in these kind of very complex matters which are before the Constitutional Court, we've grown up, believing as a community that we have the best ability to articulate the principles that are relevant for decision making. But we are not so. And this is an opportunity, and I don't know whether you call it an opportunity which is good or an opportunity which is bad, where you're going to have continuous debates from people from all walks of life, whether it's in the social media, whether it's in the print media, whether it's on the channels and everywhere else, where there'll be academicians who will come in, there'll be religious scholars who will come in. There are a whole lot of people who are going to come in and debate those issues on a daily basis. Now, there are, depending on the issues that are being actually argued before the Supreme Court, there is a lot of benefit to that, because then you're getting different perspectives which are coming through from experts who are not given a right of audience in a courtroom. Only the lawyers are given a right of audience in the courtroom. So that does help in fleshing out the issues before a court in a constitutional matter. But you have the flip side of it, of course, where you'll have the other side where people will be coming and commenting and making all kinds of, statements about what's going on in the court. But I think, as we are all saying here, you've got to take the best out of it, choose the best, make it part of your system, and just ignore all the negativism that's there, that's going to come out of this process. That's the only way I think our system will evolve, because that's where you will get better decision making in the process of these kind of matters of national importance.
Point well taken. We have almost little time left, so two quick comments. Senior Mohit Saraf, managing partner, Saraf and Partners. Now, a lot of young lawyers, do you think they'll get to learn a lot because of this? Because experience at court is hard to come by, but simply by watching these eminent advocates and judges, of how judges arrive at a judgment, what questions they ask. Sitting in office, for example, you employ a lot of young advocates. They sit and watch these things. Do you think they will arrive or they become better lawyers?
I actually read an interview. I can't remember whose interview I read. And he was one very successful man, very successful person. He built $1 billion empire. I don't remember who was he. And in his earlier years of his starting, what he used to do is he used to go and meet and interview all successful people. Irrelevant fields, he'll go and interview them. And he wrote in his biography that I did it because every time I met somebody, I realized that I can be him or I can be better than him. So what it will really do here is, and I would say when I hire my in the firm, really the average age is 35. So I would say a lot of my young lawyers will start looking at me and looking at others and start saying what they could do at 50, we'll do at 25, we will do at 35. Because there's a lot of zeal to learn, and this will help them improve. I would say this will help us also improve. I think all of us will improve a lot. I would say what it will do is most lawyers will take less brief. They will come very well prepared. They'll not be running in and out of the court. We'll all be taking it very seriously. And this is actually the entire accountability issue. So I would say it will not only learn, young people will learn, but all of us senior members also will learn a lot. And this will actually have a large, I would say a very, very, I would say huge impact on the judicial delivery system. I would say that's the reason I'm very positive. I hope it doesn't stop at the constitutional law at the Supreme Court. It goes down to the district court across. Obviously, we have to protect privacy issues of witness and litigants. But I think we have to find a way, and this should go across, because that is the time we will find a lot of this litigation disappearing overnight.
Yeah, so I agree entirely with what Mohit said. It started with constitutional law. We should widen and expand this. There's just one small issue here that I want to say. Arbitration cases. Now, there is even today a debate going on because arbitration is confidential. Now, there is a view or actually a question mark as to what happens when that arbitration matter is in the court, when it is challenged in court or when the court exercises its supervisory jurisdiction. Right. So this is where I think a little caution may be exercised. I'm not recommending either way, but this is something that we must keep at the back of our minds, because people do opt for arbitration given the anonymity and the confidentiality of the process. Subject to that, I think this is a great move, and we should definitely expand this.
Percy, but even in criminal matters, family matters, all those things, you have to have a process, as what Ryan said. You would include that because obviously a lot of these issues cannot be part of public debate.
Yeah, so it will evolve, but I think confidentiality will become question in arbitration.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.